Utah, medical malpractice cases have to be brought within a certain time period. And that makes it difficult because the time period is different depending on who made the medical error. If it is a person who's employed by the University of Utah, which might work at the VA, they might work at IMC, it's hard to know where they're working, but if they're employed by the University of Utah and working within that realm, meaning the University of Utah has a contract to send them there, then the statute to notify them of a claim is 1 year. If they don't work with the University of Utah, you have 2 years. And sometimes in medicine, you don't know that there's been an error for time. You might get a scan and they tell you it's normal, and then 4 years later you find out it was cancer, there was cancer on that scan, and no one told you. Now the 2 years is up, and in Utah you can extend that 2 years a few years, but no more than 4. If the negligence happened 4 years ago or more, with very, very few exceptions, you have no case. And the laws aren't fair, but that's another thing people have trouble understanding is, when we can take a case and not take a case based on when they come in. That's why it's important to contact a lawyer early and make sure that you don't miss your chance to at least investigate the case and get answers. I get a lot of sad cases that seem like they're clearly a case, but they waited so long because they've been grieving or didn't understand what happened, and it's been over 4 years or it's been past 2, and it's going to be tricky to prove that they can bring a case.